All right, we are live. Give it a few minutes. Mic check 1 2 testing 1 2 3. Just bear with us, people. Just let the viewing build up. Just make
Mic check 1 2. I mean, who is Mike? That's the question, isn't it?
Yeah, we are a little bit early. We are a little bit early today, guys. So just bear with us as we settle into this. And listen, while the viewers build up, obviously they're all waiting till 8:30. So give me a little update. What has been going on then this week? Give us a little. Said you're busy, so.
Yeah, we have been busy this week. I've been in Manchester for a couple of days this week on quite a difficult case. A very difficult abuse case. And then this coming week, the week that's about to start, I'm in Kent for 3.5 days on another difficult case, but we're ready for it. We've spent a lot of time working on it, and we're ready for it. And we're looking after Dad in that particular matter, and we're quietly confident that we'll get at least some common sense out of it.
What is it? A fact find?
It's a fact find, yeah. Yeah, it's a fact find, yeah. So that's the coming week. So yeah, the October was always planned to be very busy because these various lengthy hearings had come up, and it has been busy. It obviously finishes on Friday. Goodness me, it's November on next Saturday. That's quite frightening. That's quite frightening, but it is what it is. There we go. But yeah, so it's frantic at the moment, getting lots of inquiries, which are always great. It's always great to get inquiries. It's just difficult when you're already chock-a-blocker.
Yeah, we're going to have to recruit a few more. I think Mackenzie's up and down the country. We're going to have to train some people up. Let me reach out to a few people to see how serious they are about it. I think we need to definitely build up our reserves.
Yes,
to handle this load that's coming in.
It is difficult.
So I want to say we've got Mr. Mobs joining us tonight. He's reached out to me on Instagram. He's just entered the system that a non-mob put against him. He's really panicked and shook up. So look, Mr. Mobs, we are here every Sunday 8:30. We've helped many through the system. We know the system inside out. Just stay cool and composed, stay calm, try not to make contact with her. Just keep your distance. And like I said, I'll speak with you during the week. Like I said, send me a number, we'll speak, and we'll try and guide you in the right direction. You don't need a solicitor or a barrister. We can give you all the information that you need and the support that you need. And if you need representation, Mr. Ryan, like I said, he has over 18 years experience. He's a professional Mackenzie. We have all the knowledge and information needed. So don't worry, don't panic. You're in a good place. You're not alone. Don't do anything silly. It's not as bad as you think. Just stay cool and composed.
Yes, indeed.
Yes, so that's a shout out to him. Right, let me just do the intro as the viewers build in. I think maybe starting. People are waiting till 8:30. What episode is this? Right. Right. Welcome to another live episode on Disqualified Dad. This is episode 69. Now, what do we do here? For all the new followers, the new subscribers, what do we do here? We are here every Sunday, 8:30. We provide technical, emotional, mental, spiritual support, and really whatever you need to get you through the system, get you through these long, hard weeks without your children, and hopefully at some point we will assist you and help you in getting closer to your children. That's what we do here. I'm joined by my co-host, none other than Mr. Ryan, also known as That Family Law Guy on the internet. Mr. Ryan, what's happening?
Good evening. Yes, Sunday, the 26th of October, 2025. Oh my word, is this year flying by in a disturbingly quick pace. Episode 69, goodness me. We'll be hitting episode 100 before we know it. We'll have to do something special. Yeah, it's the family court continues to be chaotic and full and congested and makes decisions that aren't necessarily great amongst those that it does get right. But this week's obviously been a particularly interesting week, which we'll talk about in a bit, because there's been a bit of breaking news this week that is going to affect all cases going forward in the fullness of time.
Yes, there's a lot of commotion all over Instagram, predominantly Instagram. Yeah, there's a lot of commotion, a lot of messages flying back and forth. See messages on a few fathers group regarding the abolishment of the need for a child to want to see both parents. So there's a lot of bad feeling, I would say. It's a bad feeling, and it just sort of adds more. How can I put it? It's adding insult to injury. It's just rubbing salt into the wounds. And I think we are headed towards a future where it appears as though the powers to be, or the people in power, clearly one side has a lot of leverage, and they're slowly wiping one party outside of the family unit. They're just completely disposable. I mean, we were disposable already, but now we're officially disposable. We were, in society's eyes, we were disposable. But now, officially, in the eyes of the government, we are officially going to be disposable.
It's concerning. It's very concerning. Let's fill in the details. So there's an article of law called the Children's Act 1989, and that is the basis upon which all child proceedings in family court run on. They run on the Children's Act 1989. Now, this week, there has been an announcement that the presumption within the Children's Act that says the courts should do everything in their power to ensure, wherever possible, that both parents have a relationship with that child at the end of proceedings. That is a presumption that is welded into the middle of the Children's Act 1989. This week, there has been an announcement that that presumption is going to be repealed, in order that it will no longer exist, in order that there will no longer be this divine requirement, this holy grail whereby both parents are entitled to have a relationship with their children. That will no longer exist. Now, the domestic violence women's groups have rejoiced with this news because they believe it will allow them, it will allow abused mums to be able to find a safe space with their children without having to deal with having an ongoing relationship with an abusive father. And I recognize that. I see that. I understand that. It concerned me a little that all the media was reporting that the women's aid type organizations and all the women's domestic abuse groups were rejoicing at this news, because I don't think there's anything to rejoice about. I think it's an undermining for both mums and dads that this presumption is being removed. Now, I entirely accept that if a parent, regardless whether it's mum or dad, if a parent is abusive, and if there are grounds for a parent, either one, to not have a relationship with their children because that is not in the best interests of their children, I'm with it. I will stand and hold that banner all day long if that is the right thing to do. However, what I believe is that this repeal, when it comes through, and it's a while away, yeah, it's got to go through a legal process. But when it comes through, I think it will flag a floodgate opening of parents rushing into court with false allegations because they believe that there is a prize waiting for them now, and that prize is that they can block the other parent forever. And so I think there will be a floodgate of cases with false allegations. I think there will be a further congestion in the family court, because people will rush in now and think, I'll go there because I'm going to get him or her locked out of the children's lives. So I think the family court will become more congested than it already is. And I think what we have done this week, if this repeal is going to carry on, and there's still some process to go yet, but if this repeal is going to come to pass, it's a mistake. It is.
Yeah. Yeah, the thing is, right, I just want to highlight something. So, I mean, that was a very well articulated. I think you clarified the opening into that very well. I just want to highlight some aspects of abuse. Look, in the real world, ultimately, mum and dad can hate each other. Mum and dad can hate each other. Mum and dad, in some cases, some married couples, some relationships, at times it may appear that they want to kill each other. But ultimately, and like I said, no relationship is, it's not all, you're not on a honeymoon period forever. Shit happens, right? Now, as long as there was no abuse towards the children, they were good mothers, they were good fathers. They just couldn't get along together. My position's always been put your differences aside, move on. If one party's in danger, no problem. The weaker gender, the mother's in danger, no problem. We give her the help and support. But father can maintain relationship with the children, whether it be contact center, public place, supervised, whatever. There are mechanisms in place to ensure that the mother's not intimidated or bullied or upset. Because and I'm saying as long as there was no abuse towards the children, they were good parents. Let's just use the word good parents. Now, we represented a lady, I remember it must have been a while, a year and a half ago now. She used to smoke a lot of weed. I think she beat her husband up. She almost tried to strangle him. Now, as comical as it sounds, because we're saying, because it was a female, a mother trying to strangle a father is sort of like, we can laugh it off, it's no big deal. But the fact is, she lost contact with the children, and our position was that the children shouldn't miss out. She never did nothing to the children. Yes, she needs to look into her life, reflect within herself, sort her life out, but these children should have a relationship with both parents. That's our position. It's always been like that. Now, the problem is, again, it's that position we have in our mind, that societal conditioning that we have. If that situation was the other way around, it'd be like, no way, cut him out of the kid's life, this and that, blah, blah, blah. But the reality is, if we can do it for one gender, we can do it for the other. The kid should not suffer regardless. That's been my position. And like you said, this is now further open to abuse. If this goes through, it is just further open to abuse. The system is open to abuse against, unfortunately, many fathers, I believe.
I do believe on balance. I endeavour, as you know full well, I endeavour to be balanced in everything that I say, and I weigh the argument for mum as well as dad. I fear this particular development is going to weigh more heavily on dads than it is on mums, and I fear that there are going to be dads who are going to lose contact with their children through little or no reason, and that concerns me greatly.
Yeah, no, this is worrying. This is worrying news, obviously. So, but anyway, look, guys, not gone through yet. I believe so. It's just at the stage where it's a proposal currently, and obviously it has to run through Parliament and get certain votes and whatnot. I mean, okay, just a question that I'll ask you to kick it off: what can be done to oppose this? I mean, or to give it some resistance, or put a roadblock or a button away. What can we do?
I mean, the matter is now going to be pass its way through into the House of Parliament. That's where it will be debated. So, we need to make our feelings known to your local MP. You need to say to your local MP, look, this is going in. I think it's unfair. I think it's disproportionate. I think it has the danger, the risk of impacting specifically fathers. It'll impact some mothers as well, but I fear it'll be predominantly fathers. And I need you to object on my behalf because you're my MP, and I need you to object to this on my behalf. So yeah, that's really the next stage.
Yeah, so I think, look, if everyone's watching now, I know we always think these things are all pointless, this and that, but look, write a letter to your MP. Moment that's, to me, it appears as though that's all we can do right now. I might have to reach out to older IDS again. Hey, listen,
Good old IDS.
Our old Sorry, guys, I've got a sore throat, so it's tickly throat. I'm struggling. But yeah, I'm gonna have to reach out to old IDS. He did come through for us a couple of times, so let's see if he shows up for this one.
He has done it, yeah. I'd say
Wow.
Sir Ian Duncan Smith is excellent. I have to say, excellent. So he has supported us in the past with a couple of comments that we've made to him, and so I have no doubt he would do again.
All right, we don't have any questions at the moment. It seems to be a bit slow. I think with the rain and the weather, there may be some technical issues or a delay in the line. But we have no questions currently. So look, I'm going to talk you through. We've got Mr. Mobbs here, so I just want to address him quickly. So his missus has put a non-mol against him. I think he's got an 8-year-old and a 10-year-old, something like that. He has no representation. He doesn't know what to do. Any advice that we could give him currently? Obviously, I think maybe he might have to arrange a phone call just to give him some guidance. But
yeah, that's probably the next stage is for him to is for him to speak to speak to you, speak to me, and have some conversation, because we need to understand really what the background is. I mean, if we are saying that he's just had a non-molestation dropped on his toes, it depends where we are in that non-molestation process. Have we had has the return hearing happened yet? I.e., the hearing where you get to say you agree with it or you don't agree with it. Has that happened yet? I mean, just where are we in terms of the process? So, without knowing that, it's difficult to be able to make any real positive comment.
Yeah, what I'll do is, Mr. Mobbs, like I said, I'll send you my number. We'll have a chat tomorrow or the day after, and
struggling tonight, chap.
Yeah, I know. I might have to cut it short tonight. I think, yeah, I might get an early night at the back of this. Yeah, listen, reach out to me. I'll send you my number. We'll have a chat.
Yes,
and I'll get the details.
Yes, rather than strain your throat even more. Yes, I think we're going to knock this out at half hour tonight, guys, just because Farouk is struggling. So yeah, that's what we will do. We will do.
It's slow. Let's see. Got a few questions coming in now, so a bit slow, guys. Then we'll call it early night. If not, we'll just chip away slowly. Right.
Right. So the question reads: are we able to get to unsupervised contact prior to a fact find if the contact reports are superb and there is no risk of harm as recorded? The answer is yes, in short, but you obviously have got to make an application in order for that to happen. And depending on how close you are to your fact find, and I think I'm probably aware in this particular instance, but depending on how close you are to your fact find, some judges will be happily to consider it. Others will say, well, look, we're fairly close to the fact find. Let's just leave things as they are until we get that out of the way. So in principle, yes, you've got to make an application to do it. But it then boils down to the discretion of the court as to whether they want to explore it or not. It also boils down to, and I can give this a lengthier answer, it also boils down to the weight of the allegations that are in the fact find. If any of those allegations are related to the children, i.e. directly or indirectly involving them, then that potentially is going to have an impact on what you're trying to do in terms of contact. But it starts with an application, and it's down to the discretion of the courts whether they want to act on it.
Perfect. Right. Next question. Yes, I recognise the initials.
I'll do the reading. You've got a sore throat. I'll read it. Mother has been telling the child that she cannot see any of father's family apart from only father himself on video calls. There is a court order for calls with me. Now we just move that on, chap. Thank you. Can mother prevent other family members like siblings and grandparents from seeing the child on the video call? Well, it really does depend on what the specifics of the court order are. If the court order very clearly says that the video calls are just with dad, then unfortunately the video calls are just with dad, and you would require another court order in order to introduce other members of the family. It's unusual for a video call to be specific to one parent or to just the parent. The court often allows grandparents in particular to take part, but it really does boil down to what the specifics of your court order are. What is the difference with supported contact and unsupervised contact? Okay, very simply. Unsupervised contact means that you walk into the contact centre, you get greeted, and then they just leave you alone completely. They don't monitor what you're doing as long as you don't leave the premises. They just leave you to your own devices with your children because you're not deemed to have any degree of risk around you. Supported contact means that the room you are in with your children, and there may be other people in the room as well as with their children as well. There is somebody in the room who is a member of the team, member of the contact center team, and they're not supervising what is going on. That's too strong a term. They are watching and monitoring what is going on to ensure that there's no obvious distress or something going on that shouldn't be. So that's
right.
Go on, jump in.
No, sorry, go on. I've got another question via WhatsApp. I was going to say, so yeah, carry on if you ain't.
Yeah, so that's essentially the difference. As I say, supervised contact, there's somebody in the room. They're not directly engaging with you. They're just observing. Unsupervised contact, you're very much left to your own devices.
Right. Can we ask Dan to explain to the viewers what the burden of proof is in a fact finding?
Yes, the burden of proof. So the court system works on two guilty mechanisms. I'll use that phrase. In criminal court, it works on a system called beyond reasonable doubt. And in family court, and indeed in civil court, it works on a system called the balance of probability. So let me explain what they are. So beyond reasonable doubt in criminal court means that sufficient evidence has to have been presented in order that a member of the public who might be sat on the jury can very clearly, without any wrestling with their own conscience, draw the conclusion that beyond reasonable doubt, whatever is being accused took place or didn't. So somebody got killed, somebody got robbed. Beyond reasonable doubt, I can agree with that decision. So that's the way the criminal court works. So it's a very high level of threshold, very high evidential threshold. The family court works on a system called the probability of balance. Now, the probability of balance says that every event, every incident sits on a pivot of 50-50. There is a 50% chance that it happened, and there is a 50% chance that it didn't. What happens in a fact find is they use this system, the probability of balance system, for the judge to decide whether he believes that, here we are with our two 50-50s, the judge decides whether he believes that that allegation has moved 1% one way or 1% the other way in order to decide whether it's yes, it happened or no, it didn't. That's the probability of balance. Now, the burden of proof in family court is on the person who is making the allegations. They are the people, the person who has to provide sufficient evidence in order to convince the judge to move 1% towards them and accept the allegations are true. If you haven't made the allegation, if you're there to defend, you still need to defend your position. But remember, the burden of proof isn't with you. The burden of proof is with the other side to provide sufficient evidence to demonstrate that whatever it is that they're alleging took place more likely than not.
Right, there are 18 to 20 people watching live. Please click like, subscribe, follow and share, hit the bell button. We are here every Sunday, 8:30, just a reminder. And apologies about, my throat is pretty bad. It's suddenly gone really bad. So yeah, apologies. I won't be as vocal tonight.
Right, here we go. Thanks for the response. Do you think that mother telling the child that she cannot see my family will not look good for mother from a judge's perspective? Yeah, judges don't like parents who are trying to influence their children, particularly obviously when they become aware of it. If they're not aware of it, then they couldn't care less. But the judge will not be comfortable with a position where one parent is trying to dissuade their child or just simply instruct their child that something cannot happen in terms of their engagement with the other side of the family. So providing the judge is aware, they will not be happy that that is taking place currently as you describe. Okay, here's Kashi. Hi, Kashi. I'm battling with my ex-partner regarding child arrangements since they relocated to Poland. You want to just drop right down to the bottom, Joe? There we go. I'm struggling to contact solicitors in the UK and Poland or child services in Poland to progress the matter. Any ideas on how to progress matters? Okay. It is awfully difficult when you're trying to span international borders with a child arrangement. The situation that we have here is, from what Kashi describes, is that he is obviously in the UK and his partner or ex-partner and the child are in Poland. Now, you are looking for a legal firm who understand Polish family law. The obvious place to go for that is to surf for solicitors in Poland. That's blooming obvious, isn't it? The problem is this. Polish solicitors, like French solicitors and German solicitors and all the rest, choose not to engage with potentially foreign clients because, well, reality is because it's lazy and they don't need to. They just don't need to. And it's, to be fair, and I'm going to be brutally honest here, we have been approached a number of times over the years by clients who say, I'm in wherever, I'm in Pakistan, I'm in Poland, I'm in Albania, I'm in Germany, and I need somebody in the UK who can help me with a family matter. And we are reluctant, and I'll tell you why we're reluctant. It's because it's going to be awfully hard work. Trying to deal with the issue possibly of language, trying to deal with the issue of the fact that they're outside the country. It just makes for very hard work. So I kind of understand why it is that Polish solicitors are fairly reluctant to engage. So your next stage is you've got to look for international solicitors. You've got to look for solicitors who are based in the UK, predominantly probably in London, who operate in international family law. And that the upside of that is they are going to understand Polish law. They're going to be able to assist you on both sides of the border, i.e. here and there. The downside of that is going to be the price. They are going to be very, very expensive. I dealt with a matter a couple of years ago, to give you an example. I dealt with a matter a couple of years ago. There was only one hearing in that matter, which was in the Royal Courts in London, a court building that both myself and Farouk have had lots of time in. But there was one hearing, that was it. The mother flew over, that was also from Poland. The mother flew over from Poland and was represented by this particular legal firm because they are advertised themselves as Polish experts as well as English family law experts. One hearing took place. We dealt with the issue. It was fairly low level. It was all dealt with wonderful. Mother's bill was £17,000 for one hearing. So what I will do outside, and I know you've emailed me, Kashi, and I apologize that I've not responded to you guys yet, but what I will do outside of today, outside of this conversation, is I will send you a couple of international legal firms who have connections with Poland, and then by all means reach out to them and see what you can do. But it's a difficult situation. It's a very difficult situation.
Yes, very difficult. Kashi, just hang in there, keep chipping away. Like I said, the spirit is strong. You continue regardless, that burning desire to fight on, which is maybe that's all we need. Maybe that's all you need in the end. So just keep at it, keep chipping away. We're with you. It's just sorry that we can't do any more, or we can't give you anything more. So just feel bad about that. Right, Mr. S.
Steady, right. Okay, so we've done that one. Roll it down. We've done the difference between supported contact and unsupervised contact. We've done that one. She sounds like my mum. We've done that one. Yes. Keep going. We've done. There we go. Here we are. So, is it common for people to get unsupervised contact before a fact find, or is it reasonable to move from a contact centre to unsupervised contact before a fact find? Is it common? No. And I'll tell you why. When a judge decides that a fact find is proportionate in a matter, is appropriate in a matter, she tends to want to freeze the world. So anything that's happening at that time, he wants to just leave that in play. If, given that you are in child proceedings, given that the purpose of child proceedings is to determine what is in the best interest of the children, and given that the court has decided that a fact find is the next proportionate step for you to take in order for it to explore some allegations or a number of allegations or whatever it may be, what reason would there be? What logical reason would there be for the court to move children into unsupervised contact? Because essentially you are placing them, well, in the simplest terms, if we accept that there are some allegations within the fact find, you're potentially placing those children at risk by putting them into unsupervised contact. The court just will not do that. That is a step too far. They might loosen the contact centre a little to move it from supervised to supported. They might do that. But the likelihood of moving to unsupervised, potentially outside the contact centre, is almost nil. Is it reasonable to do it? It's not unreasonable to do it, but I also understand the risk. I also understand the issue of risk. And the court is very, very risk averse. The court will not take risk because risk puts judges on the front page of the Sun tomorrow, and they don't want that. So they will always take the safe option, and the safe option is leave things as they are.
Yep. Hope that helps, Mr. S. Right, a little bit on Mr. Mobbs' story.
Right,
We're doing fact findings.
Go on.
We're doing fact finding. Now she had 6, I have 6, I presume 6 allegations each. She lied about me stalking her. It gives us some insight. We'll come back to that. Did we cover this? We covered this, didn't we?
Done that one. Yep. Move on.
Right. I took my ex to family court. Now she doing the non-mol on me. Kafkas are on my side, but the ex is making lies about me stalking her at sports day. All right, we're getting some information here now. Is stalking a big one if you take her to court? Is it just me? She had nothing on me. What it sounds like to me is, right, my ex has 2 with me and 2 other kids with 2 different men, and both the other dads was and still nowhere to be seen. There's definitely a pattern. Shame it took me 8 years to take her to family court. Basically, you took her to family court. It looks like you were getting some momentum. If Kafkas are on your side, that's quite a big move. So in order to disrupt the waters and try and put some stumbling blocks in your path, she started coming out with these allegations of stalking and this and that and X, Y, and Z. And she tried to throw in a non-mol halfway through during this proceedings just to try and stall him, basically. That's what it sounds like to me. What do you think?
Yes, it sounds that way. It sounds difficult. I'm interested to know why it's taken 8 years to get to family court. That's half the half the length of a child of a child. Anyway, but I accept the difficulty. Now the question you've asked in there, Matt, is stalking a big one? Stalking is a criminal offence. That is your biggest problem. Family court doesn't really have a position on stalking. They just count it amongst the domestic abuses. But it is a criminal offence under the Domestic Abuse Act 2021 and under Section 76 of the Serious Crime Act 2015. So that is your biggest issue, is that if she is waving the word stalking around and if she can demonstrate stalking, now I have to say the 2 of you turning up at the kids' sports day is not stalking. That's rubbish. That isn't going to stand up anywhere. But stalking, we need to be careful. We'd be interested to know, or I'd be interested to know, and maybe you want to communicate with me separately, obviously what the basis of the non-mol is. interested, obviously, that you tell me that CAFCAS are on your side. That's always valuable. Your issue now is that, well, you're in family court for a start, so you're buried in the middle of family court, and you've got some messy elements to the case because you've got a non-mol in place. She's waving around, stalking, and all manner of rubbish. You need to tread carefully. You need to have a strategy in place, otherwise this is going to blow up in your face. By all means, I'm sure Farooq will put my email on. By all means, give me a bleep, and I'm happy to have a chat with you and tell you if we can assist. But yeah, strategy.
Yeah, I'm gonna have a chat. I've got his number. He sent me his number on Instagram. I'm gonna have a chat with him, have a little touch base with him, see where we're at. But like I said, right at the moment, just sit back, do nothing, stay cool and calm. Don't try and contact her. Don't contact anyone. We've got time. We're in a good place. It's not as bad as it seems, I would say, at this stage. Just stay cool. And what else was I'll come back to you in a minute, Matt. Something else I want to say. Right, in the meantime, this is a new name I don't recognize. Welcome to the channel. We are here live every Sunday, 8:30, providing information, knowledge, technical support, whatever you need to help you get through the system. So tune in. Can I get contact if there's a criminal proceedings in the background? Good question.
Depends on obviously what the criminal proceedings are. It depends what the nature of those are, and obviously whether there's any direct or indirect impact on the children. If the children have witnessed domestic abuse, under the Domestic Abuse Act 2021, they are deemed to be victims of domestic abuse, which means you're not going to get any contact at all. So it really does depend what the basis of your criminal proceedings are. But as a sweeping statement, I would say it is incredibly unlikely, because CAFCAS's own domestic abuse policy, which came out in October last year, does very clearly say if there's a police investigation ongoing, then contact should be suspended.
I just want to say though on that, I know a couple of cases where guys had records and stuff like that, stuff going on with the police. I'm sure in one case, don't quote me exactly, he had previous convictions and managed to get contact. So it's not impossible. What I'm saying is, maybe difficult, but it's not impossible. Yeah, that's what I'll say. Would I be correct in saying that?
You would be correct in saying that. Yeah.
Mr. S, we'd like to see you again. Tune in, and we are here every Sunday. Right, Mr. D. So positive news in family court. Mother wanted to block assisted contact on Saturday due to 5-year-old busy school schedule. Judge said spending time with father is more important than gymnastics. There you go. See, we hear, we hear all these horror stories about judges and this and that and the bias. We know it's there, but what we're saying is, guys, we don't hear about the fact that when it goes the other way. So the key is, it's possible. It can happen. Stay positive, stay focused. It can happen. Yeah. Good news. Right, Mr. M. Bruce, what's the latest on your case? Given how long you waited, do you think the new law will be applied to you where they say you're not needed? I think, do you know what it is? My case was the trial for this new law. And they're like, yes, my case, they were just trialing out this new law in my case. They just didn't tell me about it. And that just worked so well to remove me out of my children's life. They're like, listen, this is great. It works. So let's roll it out to the country. That's what's happened. But
such a drama queen.
No, I'll tell you what's happening in my case. 2026, at some point this time next year, 2026, I may have full custody, guys. This is the reality. This is the possibility. This is a possibility. This time, 2026, I may be doing this stream and you'll see my kids running in the background. It is a possibility. I might have full custody. That's where my case is at. Right. Here we go. Mr. S. What if there is no allegations against the children, but only against the ex-partner, coupled with strong CC report? Would that make it reasonable for unsupervised contact before a fact find?
I mean, at the end of the day, all things in family court are entirely at the discretion of the court. My experience on the development, the improving of child contact arrangements ahead of a fact find invariably is not a good one. Invariably, it's as I've said already, the court is very reluctant to make fundamental changes until they understand what the fact-find position is. So whilst we are saying in your matter that there are no allegations against the children, it doesn't mean that the children have not been witness to any, and I don't know whether they have or not, but it doesn't mean the children have not been witness to any of the alleged incidents, and that then makes them in party to those incidents. So it is difficult. It is very difficult to try and move the position. Your only option is to try and make a case against a C2 application to court. It will be an uphill battle. The mother applied to extend the non-mole. We already have every safeguarding in place for the handover service, and I'm fighting it with my queue. That's nice. How common is it to extend and extend? It's kind of getting silly. It's not uncommon for non-molestations to get extended, and it's not uncommon for non-molestations to get extended and then extended again. Some judges are quite reserved in that they will say, well, let's extend it for 3 months and see where we are then. And then in 3 months, they suddenly want to extend it for another 3 months to see where we are then. The more sensible judges will say, let's just leave it in place till the end of these proceedings and we'll decide on the last day. But it's not uncommon, not uncommon.
Hey, Hungry Hippo. I'll read this one out. Mr. Hippo. Hi guys, what's your thoughts of recording our children to highlight negative influence, alienation from mother? If I say children said X, Y, Z, I don't think just my words will hold weight. I think I'll go back to one of the commandments of family court. Record everything, regardless. Record everything regardless, because it is insurance. So if you need to fall back on it, it is there. That's my policy. Record everything, period. But go on, what do you think?
And I accept the principle of gathering, information gathering, evidence gathering. I think that's vitally important. But I'm just going to compromise that point now by making another one. The family court does not like children being recorded. The family court's view, albeit I don't necessarily agree wholeheartedly with it, but the family court's view is that there is never reason to record your children. It is an invasion of their privacy. It's an abuse of their innocence. And so be careful. Be very careful if you start parading recordings of your children in family court, because regardless of what strength they have to your argument, there will be a degree of backlash for the fact that you've done it.
Yeah, there is that. But like I said, guys, you don't bring it out without cause. So just to put balance to it, the recording there is as an insurance. It's not there to be used as a weapon or to throw your weight or money around. That is only if you're back against the wall and you then pull it out as a trump card or an ace card. So it's just an insurance. Right, let's grind through these last few here, as I think we're all struggling tonight.
Right, okay, how are you all? I've done my courses that the court asked me to do and therapy, etc. I've got 7 months left on my section 9114. I'll talk about that in a sec. Is it worth doing a C2 alongside a C100? Right, okay, here we go. Technical question. So, a 9114. At the end of child proceedings, the court will sometimes put in place what they call a section 9114. What that means is you do not have the automatic right, and nor does the other parent. Neither of you has the automatic right to come back to court and make an application to court in order to open up proceedings again. Both of you, should you wish to try and reopen proceedings, have to contact the judge who put in place the 9114 and ask for permission to make your application. Now, ordinarily, you will get that permission. I think I've only been declined 9114 permission once in 20 years. And there was a very specific set of circumstances as to why that was the case. We were chancing our arm a little. Ordinarily, the judge has little opportunity to say no. So that's a 9114. So there we go. The next part of this question, is it worth doing a C2 alongside a C100? You can't do a C2. until you've got a C100 that is live. A C2 is a document that you do once your proceedings are live. Currently, Majid, your proceedings are not. So you just need to do the C100. If you wait the 7 months until your 9114 runs out, you just bang your C100 in and away you go. But if you believe that you've done what you were asked to do, and rather than wait 7 months, you'd rather chance your arm now, then all you've got to do is write to the judge who put in place the 9114 and say, I have done what you asked me to do. Here is the documents that illustrate it. I now would like to make an application to the court, which is proportionate, in order that I can try and secure a relationship with my children.
Perfect. So is it not a C1A that can, or a C1 or a C1A that can
You
assist
can
a
attach,
C100?
you can attach a C1A. A C1A is allegations of specific allegations of abuse, which you attach to a C100. But as I say, C2 is in process rather than outside process.
Yeah. Right, Mr. Silent Night. Silence right. I'm awaiting trial in Crown Court for allegations of DV. I have denied these allegations, but the trial was adjourned until next year. I was having contact during the time waiting for the trial. Okay, that's fair enough. That's good.
It's good position to be in. Unfortunately, this is only a brief comment on the criminal court system. The criminal court system is even worse than the family court system, and it's not unheard of for you arrive on the day of your trial to be told that your trial is not going ahead because CPS aren't ready. They haven't got a barrister to run the case for them. They haven't got a sufficient jury, blah, 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 blah. And you can have the matter bumped out by a year or in some cases 2 years before they'll run the case.
Wow, great. Right, Mr. Stephen. She keeps making minor breaches of the interim. I'm missing 1 or 2 calls a week and insisting that she meets with the third person and me during the supervised contact. He joined us last week, I remember now.
He did, yes, you did, Stephen. Hi, nice to see you back. If the other party, Stephen, is deliberately frustrating and obstructing the directions of the court, and it is causing sufficient upset in terms of what it is that you are trying to achieve in terms of your contact, and you believe that potentially is impacting on the children, then take the matter back into court and raise it with the judge that she is not dealing with the court orders or not obliging with the court orders quite as willingly as she should, and it is impacting on the relationship.
So should he...
Sorry, very quick one. If she has legal representation, then obviously just fire a note to her legal saying, I believe your client is obstructing contact. I believe that she is being petty. I believe that she is using these disrupting tactics deliberately. Please ask her to stop, or I will return this matter to court.
And to return the matter to court, does he need to go for the enforcement order or something else? What does he need to do?
It would need to be, because I can't quite remember whether Stephen's matter was finished or whether he's in the middle of it. If you're in the middle of your proceedings, and this is just the latest stage, then you need a C2. If your proceedings are finished, then yes, you need a C79, which is an enforcement.
Just as I thought. Right, let's wrap up these last couple. Right, I heard at the final hearing there will be an opportunity for each party to ask questions to each other. Does this mean the mother could raise questions about DV? Is it a bit like a fact-finding? Good question.
Right, final hearing, or what you've just described is what we call a contested final hearing, where both parties have the opportunity to ask questions. If there are allegations of domestic abuse at any point in these proceedings, then you cannot directly, it's our pleasure, Stephen, you cannot directly ask questions of the mother, and the mother cannot directly ask questions of you. And during the case management, the judge should have decided how they were going to deal with this. So yes, questions are asked, but if there is domestic violence at any point or domestic abuse at any point in these proceedings, then the judge is going to have to find a way, if neither of you are represented, is going to have to find a way of allowing those questions to be asked. And ordinarily that would be either the appointing of a QLR, qualified legal representative, to each of you, or for each of you to publish your questions to the judge ahead of the hearing in order that he or she reads them out on your behalf. So a bit more detail, perhaps DGS might allow me to sort of narrow down my comment to something a bit more specific to you. Is it a bit like a fact finding? Well, yeah, essentially it is. Essentially it is.
Right, guys. We've managed to knock out 50 minutes, considering I think Mr. Ryan is very tired and my throat is playing up. I'm just going to read out a final comment here from Mr. Mobs. I got lots of my kids saying, "Daddy, I'll see you when Mummy lets me." I think that sums it up.
It does.
All of us. Hold on, sorry, one sec before we go. Sorry, last one. How long to get a minor breach to court? We have a fact finding in February. There you go.
Right. Stephen, if you raise a C2 today, I can't remember which court you're in, but if you raise a C2 today to say that the directions of the court are being frustrated and obstructed by this mother, you are likely to get a hearing within 4 to 6 weeks. Now, given that you've got which obviously takes us the thick end of heading towards Christmas, then obviously you've got the issue that the court essentially closes down for 10 days over Christmas. So you need to weigh up whether you make that approach or whether you wait until you're fact finding in February and then you just lay before the court, this is what has happened during contact in the interim period, and present a much larger case.
Guys, thank you for joining. Like, subscribe, follow and share. We are here every Sunday, 8:30. Just a reminder, we have been here every Sunday, 8:30 since before last Christmas. Just say from the 1st of December, we've been here, and we're approaching another Christmas soon. So yeah, join us. The viewers are building up. There's a lot more questions coming in every week. We'll try and answer each and every question. Thank you to all of those that have joined us. Hang in there, keep battling, keep chipping away, stay cool, calm and collected. It's a marathon, not a sprint. Any final closing comments, Mr. Ryan?
If you're in court this week, folks, just as I am every day this week, but if you're in court this week, I trust it goes well for you. Respect the court, and the court will respect you.
Yep, guys, play the game. Play the game. Do your thing. See you on the next one.